Dear students, welcome back to Industrial Property. So that's HOE 6065, and we were looking at trademarks last time, Article 5. So we have considered some of the various issues that arise with trademarks. What are good trademarks in the sense, or from the viewpoint of registration, and then we have also looked at issues that arise with regard to previously existing trademarks, registered or unregistered. Now, you may recollect that I sent a message also in the Moodle course, and this was about this new battle that is brewing regarding the Virgin trademark. And now, well, actually, this is quite relevant because when we looked at Article 5, for the first time, the issue of well known trademarks was introduced. And by definition, a well known trademark, as I explained, has certain criteria to be adopted and followed. And then, of course, we have always presumed that a trademark is well known if it's known to a wide section of society. And well, of course, if it's a well-known trademark, it commands a certain price and certain aura that goes with it. And as we can see in this particular case with Virgin, now the issue here is maybe their trademark is not so well known anymore. Aviation industry is down in the dumps and traveling is not happening as such. And so it's a classic situation where a licensor, Virgin, have licensed their trademark, Virgin Air, and so of course this is being used by a railway company in the US, and it seemed to be a good deal at the time, but now the licensee, the railway company, is trying to wriggle out of this particular arrangement. So what comes out of it? Well, I don't know. It'll be interesting to see. But anyways, these are some of the issues that arise, and as you saw, it was a multi-million dollar suit and the hundreds of millions of dollars. So, well, we have looked at Articles 4 and 5 as closely as possible. So now perhaps is a good time to look at some other issues. So far, our discussions have been highly theoretical, but of course, a trademark is a form of property, and so we have to now consider how is it dealt with under property law rights. So we'll be looking at something known as a register of trademarks. And well, this is a document, a public document. All trademarks that are registered are done so in the trademark office of their respective countries. And now such a document, namely the register of trademarks, is maintained by the trademark office of that country. And it contains a list of various things. So we'll talk about these issues. Sorry. Then we'll also look at what can you do with a trademark. Can it be assigned? Can it be used as property? And issues with co-ownership and licensing. So hopefully all of these topics that we'll be discussing will help you to also understand the ramifications of this Virgin trademark case coming up. This is just one of many such cases that already exist. So what's the register of trademarks? Well, as I explained, the trademark office contains this register and it's a public document available to everybody. Earlier it used to be in the form of several volumes of a book, but now of course it's just online and readily available. Now we're talking about trademarks right from the very beginning. Because remember, as I explained to you, a trademark is valid for 10 years and you can keep on renewing it. So for example, in some countries, you can have a trademark register from which is 50 years old, 100 years old, and so you have a lot of trademarks that are already in, trademarks that are removed, trademarks that are added. So it's a very dynamic living document in that sense. Now there's an example of what a register would be like. So I've given this example over here, and it's in the notes. So, well, basically, it has a page, one of many. And what would be on this page? Well, there would be the trademark number. Yes, very important. Usually, your application number becomes your registration number. although that may differ in different countries. Then you have the class, so classification, and we'll talk about classification today. Then there is the name of the proprietor, the address of the proprietor, the description of the goods or services, and then there are certain documents that are added in, or information regarding when was the trademark registered, when was it renewed, how many times it has been renewed, and if it has been licensed in some countries, then you have to also provide that information to the trademark office. And so it's either registered use or licensing, and then that information is also documented. So this is almost like your land property register in a way. So it gives a full record right from the time it was registered all the way up to today. And this would be your register of trademarks. And so all of this information is very important, of course, for anybody who wants to visit this trademark register and view its contents. What purposes would it solve or serve? Number one, of course, if you want to apply for a trademark, you just have to check the trademark register of your country to find out whether you have any issues with regard to similar trademarks that may have already been registered before you. Then there are also, well, if you, it's a property. So for example, if you want to buy a trademark, you have to do due diligence, and then you would check on the register as to what is the history of this document and this registration process and the trademark. And of course, why do you do this? Well, simply because that's what lawyers do. You don't just pay money for nothing. You have to be very sure about what sort of property you are acquiring. Then there will also be, for example, court orders. So if this matter has gone to court, if this trademark has been involved in a court of law, infringement or whatever, then that information would also be available. Now, of course, if you want to buy or sell, that information is there as well. There's also another use for this trademark register. Now, let's say I'm the owner of a trademark. So I'm Pfizer, I own the trademark Viagra, and I want to file a lawsuit against somebody who is misusing my registered trademark. Now, when I go to the court, I can't just simply go and say, I have a trademark registered and it's registered in the book. No, that won't do. I need to get a certified copy from the trademark office saying that, yes, as of today, the date of issuance of the certificate, Pfizer is the owner of this trademark. This is the name of the trademark. These are the details, etc., etc., etc. So this is very important to file in the appendix to your lawsuit. Otherwise, it's not good enough to just say that it's registered. You have to get this extract from the register of trademarks to use as a supporting document. So as you can see, it's a very important document. And if you go back to the definition of a trademark, remember earlier the definition was that it has to be something that can distinguish between products or services of one trademark owner and the other trademark owner. That's the definition of a trademark. And it was supposed to be graphically representable, but this requirement was of course removed in the latest directive. But you can see where this comes from. You have a trademark that's just a color. Well, of course, that color has to be described with a scientific terminology for it. And all of them have this numerical coding system for colors especially. Then if it is a smell, then again, you have to explain what the smell is. It just doesn't mean that, you can just say cinnamon bun smell or a cut grass smell. You have to be able to describe it in a much better manner. So all of this information has to be on the register of trademarks. Now, I mentioned a bit about this NIS classification of trademarks, and you can also find the NIS classification in the lecture notes, and that would be trademark law. So just after the directive, number 3 is the International Classification of Goods and Services, and that's a very important document. It's a professional document, and what happens is when you go to a trademark office and you want to register a trademark or apply for registration, you don't just say I want to trademark McDonald's for everything. That's not how it works. You have to specify what are the exact goods and services that you are applying for. You're applying the trademark registration for. So, I mean, there are almost 45, yeah, 45 classes. So you don't just say, I want registration in each and every class. So let's say, what are these different classes? If you look in the notes, this is just, very representative. This is not the final document. Every trademark attorney will have this big, thick book which contains every possible uh, product or service and what class it would come into. And then some products may fall in multiple classes, and vice versa. So what's class 1? Chemicals used in industry, etc., etc. Class 5 are pharmaceutical veterinary preparations. Class 6, common metals. Class 9, very important, electronic stuff, so that comes in here. And then you have class 10, surgical, medical, dental stuff. Class 13, firearms. Class 15, musical instruments. Class 16, paper, cardboard, etc., etc., etc. And then, of course, you also have class 34 would be tobacco. And then there are services from class 35 onwards. So different services: advertising, telecommunication, education services, for providing food and drink, and stuff like that. So now let's say your client is McDonald's. Yeah, and McDonald's says, well, they want to open a restaurant, and the restaurant so they would be doing the business here, and now they need to have a trademark registration. So what would you advise them? Well, number one, of course, is McDonald's, just the word McDonald's. And then there would be the label mark. I'm sure they have a label mark. So, this would be the M sign, the twin arches or things like that. Sometimes it may be in black and white, which means it is of all colors. Sometimes it may be in a specific color scheme. So you have 2 or 3 such trademarks, yeah, minimum, that they would be looking for applying for registration before they enter the market. This is very, very important. And I'll explain in licensing and everything how this plays a big role. So now, what trademark, now that we know the trademark, what classification would we go for? So class 1, chemicals, well, they don't really make that stuff. Class 2, paints, no. Class 3, bleaching. Class 4, industrial oil. Class 5, medicines, no, none of this. Class 6, common metals. Class 7, machines, no. Class 8, hand tools. Class 9, scientific stuff. Magnetic data carriers, no, none of this stuff, right? So class 10, surgical apparatus, no. Class 11, lighting, no. Water supply, no. Class 12, no. 13, no. 14, 15, 16, well, maybe they have stationery, and of course they also have, like, maybe they have these carry bags and stuff, with their label on it. So yeah, class 16 maybe. All right. Class 20, no. 21, no. Nothing here. Although they do make sometimes containers, yeah, household containers, the packing that you carry it in. So maybe class 22, no. Class 23, textiles, no. Textile use. So class 24, textiles and textile goods, yeah, why not? Maybe this could be of relevance in a way, but class 25 is more relevant because, if you go to McDonald's, they give you this t-shirt and this clothing that they have with their label mark on it, or maybe a cap or something. Then 26, no. 27, no. 28, no. 29, maybe meat, fish, poultry and game, vegetables, food stuff. Yeah, why not? Class 30, tea, coffee. Well, you do get tea in McDonald's, or coffee also. And then, well, also you have some ice stuff and everything. So that would also include, I guess, ice creams in a way. Yeah, why not? Class 31, agricultural, horticultural, live animals. No, not really. 32, water, fruit drinks. Yes. So far these are just goods, but of course, that's not what McDonald's does. They are more into services. And what services would they have? Class 35, office functions, yeah, very important. Business management, advertising, they do some of these things. Class 36, real estate affairs, monetary affairs, well, depends on their articles of association, memorandum, the company formation. Sometimes they do such stuff, especially when it comes to licensing of trademarks or such activities. So we'll talk about those, especially franchising. Then building construction, repair, installation services, yeah, that could actually work out too, because when they have franchise agreements, they often provide, as I'll explain later on, all the furniture and all the placements and how it should be and where the cashier should be and things like that. Telecommunications, 38 now, 39 transport, packaging and storage, travel arrangement. Well, if they have home delivery, although nowadays you have Bolt and Volt for that. Then class 40, treatment of materials. 41, education, entertainment. Well, you do have McDonald's birthday, parties and things like that. 42, scientific technical research, not really. Class 43, services for providing food and drink. Yeah, see, that's what they really do. I mean, they're a restaurant, so that's the most important one. That would be class 43. And then maybe something else. No, not really. So in all of this, as you have seen, obviously, you can't apply for all 45 classes. The main one emphasis should be on class 43, and then maybe 3 or 4 other classes depending on what those activities are. Well, of course, for McDonald's, money is not an issue, so they're not going to be skimping on that part. Rather, they come to you for legal advice because they want wholesome, yeah, full holistic approach. They don't want to save a bit of money here or there and then end up in trouble later on because of their particular business model that they follow. So you have to be very careful about these things. And so we will look at what are the various issues that come up. But before that, let's look at the national registration procedure. And remember, we are just looking at the national part. We are not looking at a European Union trademark. That would come under the European Union Intellectual Property Office or the Madrid Convention. No, so we're just looking at a simple procedure. You are in Estonia or you are in Finland and you want to apply for the trademark in your country under your country's laws. And of course, these are both European Union member states, so the laws would be compliant with the directive. So how does this procedure go? Well, you apply, you have a form, it could be filled online, it could be filled physically, and it would contain certain required information that needs to be filled up. And what would that be? The name of the proprietor of the trademark, the description of the trademark, the address, the class, the goods. Now, of course, if you want to apply for multiple goods or multiple classes, then you get even a sort of a preferable fee arrangement, preferential fee arrangement, in a sense that you have to pay less. So let's say if for an individual trademark, the trademark office has an official filing fees of 200 euros, suppose, yeah, imagine. Then in that case, that would be for one trademark. But now, as I said, we're looking at McDonald's, the word mark, the label mark, maybe some separate colors. And then we are looking at different classes now. So we're looking at class 43 and then maybe class 16 and then some other classes, class 35 or whatever. So when you do something like this, then of course it can be quite cheaper. So you can, let's say, just have the word mark McDonald's, just the word mark, and you're doing it in 4 or 5 different classes with a description. And in that case, you have to pay 200 euros plus for every extra class 50 euros or whatever that would be. So if you're applying for 5 different trademarks, actually that would be the case, right? I mean, it's a trademark in class this, trademark in class that, trademark in class, trademark in class. So each of this would be separate as a trademark, but instead of paying 200 for each such form, you can just do it all together. And so you save a bit of money in that regard. And of course, you do all of this, you submit the information, and now your trademark office job is complete. Now the trademark officer will look at the different provisions that they have under their law, which are quite similar to Article 4 and Article 5 that we saw earlier from a directive. And then, based on their internal guidelines, theories, case laws, whatever they have, then they make a decision. And so the examination process now takes place. And well, as a trademark attorney, let's say you're a trademark lawyer and you're doing this job. So how does this go? Well, official filing fee 200 euros plus a bit extra for everything. Your own personal fee would be just for filing, preparing documentation, filing everything, and maybe attending an examination. And if it all goes through, then just getting the registration certificate. That would be another 200, 300 euros per trademark. So that's how much it would basically cost: 400, 500 euros per trademark, if everything goes smoothly, of course. You don't need a lawyer for this. You could do this yourself as well as a client. Now, what happens if it goes for examination and now the patent officer says, no, Article 3 of the directive, this is affected, Article 4, Article 5, all of these are problems. And in that situation, what do you now do? You have to submit more evidence. You have to show that you have used it, and because of your usage of this trademark, it has now become more well known, it has a reputation. And so remember, Article 4 had a list of what are bad trademarks, and then it said, but if you have used them, you could go through. And Article 5, of course, is, there will always be competitors, and the trademark office will say, hey, your trademark McDonald's looks very similar to a restaurant called McDonald's that everybody goes to. So of course you have all of these complications. Now in this situation, you can have cost overruns in that sense. Now what would this mean? Well, let's say it's a simple situation. You apply, trademark office, they examine it, and they say, well, yeah, okay, it looks all right. And yeah, so they can say, well, we could accept the application and allow it to be published. And or they would say, we refuse the application, in which case an appeal would lie to the appointed tribunal or the court or somewhere. And of course, once an application has been published, for example, anybody, any Tom, Dick, and Harry could apply for opposition proceedings, and they could oppose and create some problems for you. So basically, what are we looking at? You apply for a trademark office says excellent, goes through, no problem at all. Or the trademark office says no, it's a bad trademark, in which you have a problem. Now usually it's never either of these two extremes. Rather, what the trademark office would say is, well, it's a good trademark, but it has some problems, and you do some changes to it, and then we will advertise this before acceptance. And if anybody has a problem, then they can come and oppose it or whatever. So the trademark office is playing it safe. Then nobody can tell the trademark office that, oh, you people are corrupt, or you have done something wrong or something. No, it's a transparent procedure. It's like getting married. You want to get married, you give a notice. Anybody has a problem, they can come and object to the marriage. So the priest or the registering officer has no problems anymore then. And the same even applies over here. So now, well, who would oppose? It could be, for example, your business competitor. Yeah, and you'll have lots of business competitors once you are established in a field. It could also be maybe just somebody who has plenty of time on their hands. For example, there was this FCUK case, yeah, and so they applied for the trademark registration, and then some 80-year-old random person just turns up and opposes it and says, well, I don't like this trademark because it sounds vulgar, and I don't like my children wearing or grandchildren wearing such t-shirts. Now, of course, it's not always straightforward. There may be some people behind this person, the opponent, who are pushing him or financing him or whatever. So you never know. Anyways, well, if it goes into opposition, now this is going to become a quasi-judicial proceeding, and it's not simple anymore now. All right, now it gets complicated. Your trademark officer has, it's not, this is not a pure legal proceeding, so you're not covered by rules of evidence or criminal procedure code or civil procedure code of the country. No, that would go for a courtroom. But this is not a courtroom, but this is a quasi judicial proceeding, so it's a semi courtroom, and the registering officer or the trademark officer is now playing the role of an administrative judge in a way. And so you have to give her or him respect, and this is going to be almost like a court proceeding. And this is now where you have to file your evidence, your affidavits, and bring in your expert witnesses or whatever. And so of course it's not as formal as a court proceeding, but it has all the whole bureaucratic things that have to be done. And because of this, now the lawyer is going to charge per hour. So remember, I told you earlier, for a trademark, official fee is 200, your fees would be 200, so 400 or 500, and a trademark can be done, it can be registered. Well, not anymore now. If this is going to go into an opposition and it's going to be a long drawn affair, and these things can last for a month, 2 months, and maybe even more, then in that case this is like a proper trial, and so the lawyer will charge money accordingly. And therefore, at these stages, it's a good idea to have a proper lawyer or somebody trained in the law, because otherwise, this could end quite badly. So let's say you go through the whole process and everything is fine and it's worked out, and now you are in, and the trademark office says yes, you are successful in this situation. You will get a certificate from the trademark office, and it says your name, your address, it says the trademark details, what are the classification, the goods, description of the goods and services, and then a seal from the trademark office saying that your trademark is registered. So this is now proof of registration. And now you have to start paying immediately, so you have to pay for 10 years in advance. Yeah, and so you pay the fees, and so now you have a registration for 10 years. And after 10 years, if you want, you can apply for renewal. So you can apply again and it renews, and then again and it renews, and again and again. And so this is the process, and this is what you have to do. So that's how the trademark process goes, and it's quite straightforward. And of course, sometimes it may happen that you forget to apply for renewal. Yeah, well, that's a bad situation. Usually you get a notice from the trademark office telling you, hey, your 10-year period is coming over, please renew again. But sometimes it may not come through. Sometimes you may have sold on or moved on, or it's not registered properly in the register of trademarks, that the change of ownership details, or sometimes it's just too many trademarks and it's not fully computerized. Now if that happens, well, you have a 1 year grace period, you can always apply. But if you don't apply, then of course you can have problems. So we'll talk about some of these issues in the subsequent paragraph that we're looking at. And of course, now remember, you could have a trademark, and it could also contain multiple trademarks within a trademark. Yeah, so if you look at a packaging, or let's look at a car. All right. So my wife has a Toyota. Yeah, Toyota is a company. But you see, the model of the car is Corolla, the hybrid Corolla. So of course, what you're looking at over here is that there are two trademarks already on the car. One is the Toyota symbol, and then the other is the name of the model of the car. The same also goes, for example, if you look at your medicine packets. Yeah, so if you have, I don't know, a box of Viagra at home, why, I don't know, but if you have, then if you look at it carefully, you would see that there is a house mark. It's called Pfizer. That's the name of the company. It's also a registered trademark, and it would be on all their products. And then you have the specific name of the product, that would be Viagra. Sometimes it could be that there are different types of Viagra. So maybe you have Viagra 100, Viagra 200, Viagra 500, I don't know. Yeah, Viagra Senior, Viagra Junior, whatever. So all of these are different trademarks, and as you can see, they all come up on the label. And of course, you would have R in a circle, which would imply it's a registered trademark. All right. If it just says TM, it means it's applied for. So if you look at the trademark carefully, you should be able to see a lot of these things. And I've also put up an example, a sample of a label. So if you were to look at this sample of a label, it's about Duracell, so it's in the notes. So when you see it, it's Duracell. That sounds good, Duracell, yeah. And it says product is manufactured by Vidis GmbH Germany. Yeah, okay, that sounds good. And then it says Duracell is registered trademark of Gillette company. Yeah, that also sounds good. And then you see here it says made in China, and you're like, what? What's going on here? So of course you have Gillette company, who's the owner, and they are maybe America based, US based. Then Duracell is their trademark, which is registered all over the world, including in European countries. And then you have Vidis GmbH, who's the manufacturer, but they have licensed manufacture to their subsidiary or licensee in China, so it's made in China. So all this information you get from the trademark, from the label, and so if you look carefully, Duracell, it has R in a circle, it also has C in a circle, which implies copyright. So you're trying to get protection from every possible angle over here. All right, and so that's your trademark registration gone through. Congratulations, it's there. But now this is a bit different from other situations. Now let's say you have completed your Bachelor of Law studies. You get a certificate. That's it. Wow, you're a Bachelor of Law for life. Nobody can take it away from you. Nobody can say after 5 years, oh, you're not using your law degree. You're working in the military or somewhere else, and so we take away your law degree. No, we can't do that. Of course, maybe you're licensed to practice law. That could be a different situation. So the same way, a trademark certificate should work, but no, sorry, apparently it doesn't work like that. Now what happens here is you get a trademark, it's registered. This is like a public document, but of course it's also a public service, and you have to use your trademark. If you don't use your trademark, you lose your trademark. Now, this can be quite a problem. So, well, legally speaking, just getting a trademark registered is not the end of it. I mean, it's still a sword hanging over your neck. You could still lose your trademark under certain circumstances. Even your registered trademark can cease to be registered. And there are four main situations. One would be invalidity. The trademark should never have been registered. It's so against Article 3 or Article 4 that it's ridiculous. How did it even get registered? Something is seriously wrong here. Now that's very rare. Yeah, because as I explained above, the procedure that they do, well, they apply for a registration, the trademark office advertises it, everybody is given a chance to give their views, takes a bit of time to get registered. So everything gets sort of filtered out, all the problems get sorted out quite easily. So it's very rare to be stuck with an invalid trademark. Revocation, although is a different scenario. Revocation could be because of what happens post registration. So you got your trademark registered and then you messed up. You did not use it in a genuine sense, or the trademark has become generic or misleading, or there are other grounds that are out there. And so these are some of the issues that come up. And of course, what are they covered under? So if you were to look at the directive, then you can see, for example, over here, the grounds for the loss of a trademark here, of invalidity or revocation of a trademark. So Article 6 and Article 7, and then lack of distinctive character or reputation, Article 8, Article 9 is here, and so there are some of these rights that you have to be very careful about, and they outline what are the various grounds on which you could lose a trademark. All right, so we have to be very careful about this. And if you look at the lecture notes, so where are we? This would have been in the lecture notes let's see, taking a bit of time to open up. Internet is a bit slow. um, yeah, okay, so that's here. And so, sorry, just a moment, just making sure we are on the right track. Okay. Yeah. uh, okay, this is relative grounds article lecture 3. And okay, sorry, so let's see lecture 4 notes. And this should cover, yeah, register of trademarks. So what is covered over here? So articles 19 to 21 of the trademark directive list the different grounds. Yeah, so you have to be careful about that. And so you have to read these different articles over here. It's in the new directive, and so these cover various aspects. Section 4, revocation of trademark rights, and so you can read about them in more detail. And revocation, of course, is quite a problem. It always causes litigation. So we'll be looking at a lot of case laws in that regard. Then third ground is you could surrender your registration rights. And why would you do that? Now let's say Ford made the first car was Ford Model T. Yeah, then they made Ford Model A, and then they made Ford Model whatever, and then they have all these different models. I'm talking from the 1920s onwards. So now today it's 2021, March. Does Ford still make Ford Model T? No, I mean that was 100 years ago. So why the hell would they keep the trademark? Well, of course, in this case, maybe because they have spare parts, or maybe they have some, cultural, historical reasons. But otherwise, if you don't use a trademark, why do you want to keep it? You're just paying for nothing, so that's a waste of money. So you can always surrender your trademark, and that would be the end of it. Yeah. And of course, lastly is expiry. Now this is where it gets tricky. You were supposed to renew your trademark, you forgot to renew for whatever reason. Yeah, it could be anything. So as lawyers, we all go through this phase. It's very embarrassing sometimes. Client gave instructions 10 years ago, nobody in the law firm followed up, nothing happened, something went wrong, and now the client asks you where's the trademark, and you're like, oh, I don't know. And so of course, you could either lose your trademark in that sense. You could try to apply for renewal, or in that, if that doesn't work out, you can just simply apply for a new trademark and claim that you've been using it for all these decades or whatever years, and then sort of try to get that sorted out. Okay, so there are some examples on these things and some case laws, so maybe we can talk about them next time. Yeah, so we have looked at a lot of issues here so far. Basically, we have seen how a trademark works in a sense as a property, and of course how you can register it. Yeah, so that's the main thing that we focused on. And after registration, of course, we also explored, I spoke about what happens post registration. So nothing is always so rosy in life, and you have to keep up the tempo. And so let's stop here for today, and then next time I will talk about revocation for lack of genuine use and go into more details, and of course also a lot of case laws in this regard. So thank you for your time, and see you again next week. Goodbye.